Yeah.
it is important for courts and practitioners to take a look at, because what it does, what ultimately what this database does, and what JSIN is trying to do, is give courts and the public a real world perspective on actually what is happening with respect to certain classes of offenders, as opposed to looking at the sentencing table.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing. Hey everybody, Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. Hey, have you heard of this thing called JSIN? It's the Judiciary Sentencing Information that's put out by the United States Sentencing Commission. JSIN, such a nice little name, JSIN. It should be Jeffrey. Was created by the Sentencing Commission. It's a resources, I guess it was designed for judges who want to consider sentencing statistics, which is a thing we talk about all the time on this podcast. But so the judges, want to determine what's the appropriate sentence under any given guideline. And so this database is created by the Sentencing Commission. But is it accurate? Are the stats right? Could this thing do more harm than good for our clients? That's what we're here to talk about today, ladies and gentlemen. So, helping us get set for sentencing, who else would we have to talk about JSIN and the sentencing statistics than none other than Mark Allenbaugh, who, if you've heard this podcast at all, is the sentencing statistics guru, the founder of sentencingstats.com, my good friend and colleague, Mark Allenbaugh. What's up, man? How you doing?
Hey, Doug. Good to be back. How are you?
I'm so swell. I can't even begin to tell you.
Good.
Jason, we're going to talk about JSIN today, and I would like to say, this is your domain. You
Yes.
are the sentencing stats guy. So,
Yeah.
dude, if we have JSIN to just go in the sentencing database, what do we need you for?
Right. Well, that's a good question, and I will say that I was very pleased to learn about JSIN, and that it's being used and that it's a pilot program. It was, as you noted, it was created by the commission, I think in partnership with the Federal Judicial Center, and it was just launched this last March in a pilot program in about 30 different jurisdictions. 31 districts throughout the United States out of the 94 districts. And this has been an overlooked area of the Sentencing Commission. Everybody has been focused since the commission's inception on the guidelines. What do the guidelines say? How to apply the guidelines, et cetera, et cetera. And then once Booker came out, how to vary from the guidelines or when to vary. And we started getting all this discussion about the empirical basis of the guidelines and whatnot. But what has always been neglected is, I think, the commission's most important mission. And it's not just the creation of the guidelines, certainly that's important, but it's the collection of data, because that's where the guidelines were created from, was data. When the commission was first created back in the mid-'80s, they looked at 10,000 prior pre-sentence reports created actually by the parole board at the time, and collected data from that, not just on sentences, but also what have come to be known as sentencing factors or sentencing enhancements. In other words, what was it that judges were looking at that was important in particular cases? And so, for example, some of these things would be obvious, like in a fraud case, you'd look at the loss amount and what have you. But what wasn't so obvious is, well, how much time in terms of prison is $1 worth, and that's where they started looking to see where the cutoffs should be for particular dollar amounts, and that's been adjusted through the years. But also they've developed other sentencing factors such as the number of victims or the role in the offense. These are factors that they found originally that judges had been looking at. And since that time, the guidelines have been amended over 800 times to either add new SOCs, sentencing offense characteristics, or other types of adjustments to the guidelines. Sometimes Congress tells them to do it, but more often it's been because of the data that the commission reviews and looks at and sees that we need to up either the sentence here, or we need to provide an adjustment over here. Generally, it's been they've been pushing the sentences up and not providing a bunch of adjustments downward. Although they have recently, we could talk about that in another podcast. They've provided a new downward adjustment for 0-point offenders. But at any rate, it's the data collection. The point simply is that I'm trying to make is the data is so rich and robust that to my knowledge, the sentencing data that the U.S. Sentencing Commission collects is the most robust database, criminal justice database, if you will, in the entire world, because it gives you an entire. It doesn't give you the entire look, but it gives you a very broad look at each offender. Not just in this database, they collect not just the sentence imposed or the guideline that was that the person was sentenced under, but all the different SOCs that applied, whether there was a role in the offense enhancement, whether they received acceptance of responsibility, the defendant's age, the defendant's education, their race, their gender, all sorts of stuff. And it's a very, very rich, unfortunately convoluted database, which I think is why my job, I still have some job security here, trying to interpret the database. But it is important for courts and practitioners to take a look at, because what it does, ultimately what this database does, and what JSIN is trying to do, is give courts and the public a real world perspective on actually what is happening with respect to certain classes of offenders, as opposed to looking at the sentencing table. And as we know, since Booker, the sentencing table is not mandatory. Judges do not have to follow the sentencing table, and very often and more frequently, they're not, especially for economic offenses and even for like child pornography offenses.
Right. Well, and tell me, because if the way I look at this is also the great irony of when you talk about, one of the main goals of the creation of the sentencing guidelines is to manage the data. I think it's fair to say that one of the other main goals in creating these sentencing guidelines was to create uniformity in sentencing. And to me, the great irony is now there's so much disparity in following these guidelines. In other words, if the judges, because they used to be mandatory pretty much, you had to follow these, so these sentences were going to be more uniform. After Booker, the judges have discretion, they can deviate. And as we've talked about on the podcast many times, they're deviating more often than not, more than 51% of the time. So now we have to see, okay, there's no uniformity in sentencing, so we need this database to see what is the mean or average or sentences, so the judges understand just how much of a deviation there usually is. So to me, the need for this database is an expression of the great failure of that goal of creating uniformity. If we had uniformity in sentencing, we wouldn't need this database.
Well, I disagree. And,
okay, good.
And I disagree, because you could still have uniformity. You're going to always need data. Let me back up. When the commission was first promulgated, as I noted, it looked to prior data to create the guidelines. But what it had stated in the introduction, and it's still there, the introduction to the guidelines, is that the guidelines are a work in progress, and they're constantly to be refined based upon data. And the way they would get feedback from the courts is through the sentences that were imposed. But they haven't used that. They have not. That is the great promise that the commission has not followed, at least to the degree it should. Very often, as I had mentioned before, Congress will pass legislation that's not empirical at all, just completely political, add this enhancement, add this guideline, or they'll create new offenses and tell the commission you have to create a new guideline for this, and there's no empirical anything to go off of. But basically what the commission should have been doing over the years, especially since Booker back in 2005, is start revising the sentencing guidelines to match the data. The feedback is coming from the courts. And for example, the child pornography guideline, 2G 2.2, judges more often than not, about almost 2/3 of the time now, impose sentences below that guideline. Well, that's telling the commission your guidelines ratcheted up too high. You need to adjust it downward. Same thing with the economic offenses and some other types of offenses. The offenses against the person, like murder and manslaughter and stuff, judges tend to sentence within those guidelines, so you don't need to touch those. The illegal immigration or illegal reentry guideline, judges tend to sentence well within those guidelines, mainly because they're so small, or they impose such a low sentence to begin with, so you don't need to touch that either. But you look at the data and you get feedback, and you use that feedback, or you should. And that's really where I think the commission has fallen down until now. And so it is so, I think what the commission is trying to do here through these pilot programs is to see how judges use this data. And I'd like to say one thing, that where JSIN, though, I think there's a big hole in JSIN that that should, and frankly, I don't really have the answer for this, how to do this, other than hire somebody like me. But what JSIN, really what the data can be used for is not so much what sentence should I impose, but to identify similarly situated offenders. That is the beauty of this database. Really, that's the beauty of the guidelines, is the guidelines tell a judge what are the important factors to look at. I mean, do you really care about the guy's height? Or do you really care about how many children this person has? Maybe, maybe not. But is it in the guidelines? No. If it's not in the guidelines, what this expert sentencing agency is telling you as a judge, here are the factors that are important and how to weigh them, but not necessarily anymore for purposes of how to impose a sentence, but now with the database, how to find similarly situated offenders. And now once you find similarly situated offenders, now you can see how they're being sentenced. So I mean, that it seems like seems like a distinction without a difference, but it isn't. It's a very important step to use the database to find similarly situated offenders before even looking at a sentence, because that really, this goes to the uniformity point that you were trying to make. Once you find the similarly situated persons, because that's what uniformity is all about. It's not that everybody gets the same sentence, no matter if you commit murder or tax fraud. No, that's not what we're talking about with uniformity. We're talking about similarly situated offenders need to be sentenced similarly. So it's important to get that first part right. That's so critical, the similarly situated. And that's what the database and the guidelines tell you.
All right. So for people who are listening, just so you know, this really does apply to you. I didn't realize it was in 30 jurisdictions already, but I've seen people weighing in, like, so I know it's in New Mexico and South Carolina and some other places, but you're saying 30. So what's going to happen, 31, and what's going to happen is you're going to, every federal defendant gets what's called a pre-sentence report, which goes to the judge to help the judge decide what the sentence should be. And what's going to happen is, in that pre-sentence report, you're going to start seeing a special paragraph on JSIN, and the probation office is running their own calculations on the judiciary website, on the Sentencing Commission's website, and they're going to write a paragraph. And so you've got this up right now. These are all the districts.
These are the districts that are
mine yet. No Arizona yet.
And no California. Another real big ones, except like New York and Texas. So
Alabama, Arkansas, Connecticut, DC, Georgia. I won't go through the list, but we'll post this. I'll put this slide on and by the way, I'm going to put the link to the JSIN website on my show notes at setforsentencing.com, because you can actually go there and use this and play around. There's an introductory little video at the top and give you an idea. But the point is, if you're listening to this probably is going to affect you and going down the road. My guess is we're going to start seeing these in every pre-sentence report eventually. And the question then becomes, like anything in the pre-sentence report, what do I do with that? How do I challenge that? Do I just say looks good and move on? Or is this going to be something, that helps me, or is it going to be something that hurts me? And how do I know the difference?
Yeah. Well, it could be both. It could help, it could hurt. And there's problems with it. And I've already alerted the commission of some of the problems, and I've found more. I'm glad they're doing this study, and I'm glad they're doing this, but they have a lot of kinks to work out on this. And some of them is just a fact that I think that the JSIN portal or the tool doesn't provide enough information. But I think we've spoke a lot about JSIN. It probably would be helpful to actually walk through it and do it.
Yeah.
It's really easy and quick.
So if you're listening to this on the audio, you might want to do this on the YouTube, because we're going to do this visually. We're going to walk through. And by the way, if you didn't get my Jeffrey reference, it's from the movie Get Him to the Greek. When the world gives you a Jeffrey, stroke the furry wall. So I just felt like I needed to get that out there. It was very important. Many people are scratching their head, but I wish this was the Jeffrey, not a Jason. Go ahead.
Okay. So here, I'm just gonna. Can you see the website here?
I can.
Okay, I'm gonna just reboot it so we can start over.
Do we get to watch the really swell video at the top too?
No. We're not going to watch the video or any of that stuff. We're just going to get right into it. So once you get to JSIN, the Judiciary Sentencing Information Portal.
Again, link on the show notes.
Yeah.
Go ahead.
This is what you're going to see. You will see a picture of the sentencing table in the middle of the screen, and on the left side of the screen, a little bit too small, frankly. I think a lot of people could miss this easily, but it's where you select the guideline, the primary guideline that the individual is being sentenced under. Then you have two other options to click, whether you want to look at data where the individual is being sentenced under 924C. So there's going to be some consecutive sentences there, or not. You can deselect that. And the same with 1028A. And that has to do with aggravated identity theft. And you usually see that in economic offenses. That carries a 2-year mandatory minimum, or a 2-year consecutive sentence, frankly, but we often just refer to it as a mandatory minimum. The one problem here, though, is there's no selection for drug mandatories. If you're not all drug offenses carry a mandatory minimum, depending on how it's charged. So immediately right out of the gate, drug offenses are the second highest number of offenses prosecuted in the United States on an annual basis, second only to immigration offenses. And not all of them carry mandatory minimum penalties. So it'd be very important, if you're going to use this, to be able to filter out mandatory minimums. Because if you have mandatory minimums inside of your universe of data that you're looking at, and your particular person that you're sentencing, if you're a judge, isn't facing a mandatory minimum, then all the averages and medians that are going to be reported are going to be skewed artificially upward, and you're not comparing apples to oranges.
Right.
So I'm quite surprised.
And just so people who don't know the fine points, mandatory minimums are statutory. Therefore, they have nothing to do with the sentencing guidelines. They're just
correct
mandatory minimum prison sentences that have to be imposed regardless of what the guidelines say. So you're bringing in these this, I guess, for lack of a better word, data that has really nothing to do with the guidelines, but it's skewing the results. Is that fair to say?
Correct. That's correct. That's correct. And then finally, down here on the left-hand side, you have this big long paragraph that talks about sentence length data. And there's a little box down here that I have already seen very often. Probation officers forget to check it when they are reporting on the output that we're going to do a test run here in a second.
Okay. So that's the first just easy tip. If it's in your pre-sentence report, take what they got, go there, check that box, and see if it's the same result as what's in your pre-sentence report.
Right. Exactly.
Okay. All right.
Exactly.
It's a small little box too. Like, it's easy to miss.
It's easy to miss. Exactly. And the commission really needs to make that bigger and more bold. This is not the most user friendly, even though it is once you know what you're doing. It's a very easy tool to use, but visually it needs some work to help those that are new to it. So we're going to let's look at an economic offense. So 2B 1.1 is the main sentencing guideline for economic offenses. And I clicked up here on the guideline. You have a drop-down menu to all the guidelines. So I'm going to scroll down to 2B 1.1. I'm going to click that.
Yeah, this is your standard fraud guideline
Yes.
that we deal with all the time for any economic crime. Go ahead.
Now I'm going to check the box down here, include sentence data length at the bottom. I'm also going to keep the mandatory minimums 0. I don't want any 1028As. I don't want any aggravated identity theft in there, and I don't want any 924Cs, and you're not going to see that in an economic offense.
Right.
But I'm also going to click the box down here. And what that means is when I click the box, I'm asking JSIN to report back to me not only the averages and the median sentences for those that actually received a sentence of imprisonment, but also to include all those that received what's called a non-custodial sentence, generally probation or a split sentence like probation and home confinement or something along those lines.
Okay, so now, so I can translate, you see the problem with not clicking this box. There could be a whole subset of people who got, say, probation, time served, things like that, who aren't going to be reflected in this data if you don't check that box, which means the data is always going to be higher without those zero incarceration sentences.
Right.
Why would they even not include those? Why do you have to check? Like, why wouldn't those automatically be part of this calculation?
That should be automatic. There is no reason that I can think of, if I'm a judge, why I would want to only look at those that received a sentence. That's just arbitrary, because if probation is, that's a sentence too. So I want to see the whole universe.
To me, my skeptical brain is that this whole idea we've talked about over and over again, that probation is like an afterthought, or it's like, oh, no, we would never give probation in a federal case like this, when the reality is it is pretty hard to get these days. But before the guidelines, what? Common, very, very common.
They're very common. They're almost 60% of the time. The default sanction was probation.
Right. So this, to me, is in line with that. We went from a sentencing regime where the default used to be probation. Then these guidelines came around. Nobody's getting probation. And now if you even want to know the dirty little secret that some people still get probation, you better check that little tiny box.
Yes.
That's that's the way I look at it. Anyway.
Yeah. So make sure
not cool.
That's why they need to make that much more prominent, and so people don't forget to check the
just
box.
Build it into the data, man. Who cares?
Right.
Anyway,
or if you're going to check anything, check a box to take out all the for whatever view that's what you wanted. Right. It should be the default. It should be a default setting. I agree. Okay. So now here's the sentencing table. Now what you do is once you know what your total offense level is, by the way, total offense level or final offense level, kind of synonymous terms. That means the offense level after you've calculated everything, including acceptance of responsibility. So at the very end, once you calculate whatever the offense level is, if it's a plea agreement or a plea, generally the defendant can get 2 to 3 points off. So that's once you have that total number, that's the number, that's the offense level you're going to look at here, as well as your criminal history category. So,
and so sorry to keep interrupting, but I think it's another valid practice point, which is to say, we don't always know what the final guideline calculation is going to be until the day of sentencing, because a lot of times we're arguing about it. And that even though the pre-sentence report says the guideline should be X, we say no, they should be Y or Z. And so it's probably behooves you, if you're going to do these stats, that you better run a scenario for each they say and what we say, so that the judge understands those numbers each way.
Correct. Okay. So let's do one right here. Let's just say final offense level of 13 in criminal history 1. So we go over here to where it says 12 to 18, and we're going to click on that. And We see the filter running over here, and here's the output that you get here on the right-hand side in the result. So first, it just confirms up here at the top what we selected. Guideline 2B 1.1, final offense level 13, criminal history category 1. And the guideline range there is 12 to 18 months. Okay. Now we have this narrative that it spits out, that JSIN spits out. And again, I forgot to mention this, but this is limited to just the last 5 fiscal years. And a fiscal year for the federal government, for the Sentencing Commission, begins on November 1, excuse me, begins on November 1. It ends on October 31, and it starts on November 1. So fiscal years 2017 through fiscal year.
So I have to ask you, in your data brain, is that
Yes.
a good fact or a bad fact? Are you glad it's limited, or it doesn't make any difference?
Well, no, it all depends. You know, it's kind of arbitrary, just the last 5 years. I think what the commission was thinking, though, is, you know, these are the most recent trends. This will give a judge kind of a snapshot about, you know, really what's going on right now. Because as we know, since Booker back in 2005, sentences have generally trended downward. But here, what I don't like about this 5-year limit is the pandemic. The pandemic really messed with a lot of data, if you will, skewed it one way or the other. We had a big dip in sentences, in the number of sentences, and also the type of the types of sentences that were given, as well as the degrees of variance and all sorts of things.
That might play to the defense side favor, though, because these are lower.
Not necessarily. It could really be all over the place. That's why what would have been better is a 10-year look with a trend. If they could have offered a trend analysis where we could see, you know, if there was enough data. You know, one of the things too is you're only, you know, there are only so many cases sentenced at each level in any particular year. But if there's enough data, a 10-year trend, I think, could have been a lot more informative, as well as a 10-year cumulative look, or in this case, a 5-year cumulative. But this seems to be just a little, I think 5 years is a little too myopic. And I certainly would want to, if we were just going to look at 5 years, I would also at least like to see a trend for the 5 years on where sentences are going and what have you. So at any rate,
can I ask you, not to do like shameless pluggery for you, but if somebody needed a 10-year trend or something beyond those 5-year stats, is that something?
That's what we do at Sentencing Stats. We do the trends. And we can go all the way back to 2002 to pre-Booker. So if that happened to be important to somebody, but we do the trend analyses. Yes,
I thought that might be the case. Proceed.
Okay.
And by the way, what I'm looking at here is exactly this. What it shows going to show up in your pre-sentence report. They're going to do. You can export it to Word, and they're going to do a cut and paste of exactly what they say in there, and that's going in your report as the gospel.
Right. Okay. And this is what they say. So it'll always spit out these 3 paragraphs here. The second and third paragraphs are just boilerplate. It just says that the commission isn't recommending these sentences, whatever the data say. So don't worry about those second and third. They're always going to be the same, the paragraphs. It's this first paragraph, excuse me, that's the most important. So I'm just going to read it out loud for your listeners. So during the last 5 fiscal years, fiscal year 2017 through 2021, there were 1,123 defendants whose primary guideline was 2B 1.1 with a final offense level of 13 and a criminal history category of 1. After excluding defendants, and this is important, after excluding defendants who received a 5K 1.1 substantial assistance departure. So this is excluding all that. Now, why would you want that excluded? Well, if you're defense, you really wouldn't want that excluded, because if somebody gets a 5K, you know, that's going to drive the numbers down and whatnot. But to be intellectually and academically honest, those should be excluded unless your client did receive a 5K. So here's another problem.
Hmm.
About a quarter, depends on
And
the offense type.
I'll just make sure everybody knows a 5K for substantial assistance is what it sounds like. You've cooperated against other people in your case or given them information that they didn't already otherwise have. So you're basically a cooperator at that point. And if you give a substantial cooperation, then the government files what's called a 5K1 motion
Right.
to reduce your guideline range, your sentence. It could be a small reduction of a level or two. It could be a big reduction of 4, 5, 6, 7, 8, 9. So you just never know.
Right.
But so it does make sense that they're going to take those out of there because that's a very limited subset.
Well, it only makes sense. It only
Yeah.
makes sense if the case you're looking at, the defendant you're looking at, isn't getting a
Didn't.
5K.
Right.
Then that makes sense. But
Yeah.
what about all those cases, and there's a lot of them, that get 5Ks?
Yeah.
There is no provision here in JSIN to do the reverse.
Yeah.
I just want to look at the 5Ks. I want everybody under 2B 1.1, got a 13, criminal history 1, that also received a 5K.
But every 5K is different in every case, depending on the level of cooperation. So
Not
what if
well, yeah,
somebody got a 1 level
well,
5K
yes,
because they barely cooperated? Some got an 8 level 5K because they, turned in the entire mafia.
yes and no. Yes, yes and no. But what's important to look at is very often I hear this from counsel all over the United States. Well, the prosecutor in my district says that the most that they ever do is 2 levels.
Yeah.
Or the most that they'll ever recommend is 25% off the bottom. Or they don't make a recommendation. They just leave it up to the judge. Well, first of all, what's important to remember with 5Ks is, in the grand scheme of things, it doesn't matter what the government recommends in terms of the 5K. It's up to the judge. The court or the government can say we recommend 2 levels. The judge could go 3 levels. The judge could go 1 level. The judge could do nothing. Or it's ultimately up to the judge.
Yeah.
And so what's important then is for a judge to get an idea about, well, what are 5Ks like in my district or nationwide at this? Are they coming 50% off the guidelines, 80%, 10%? Who knows? You're not going to find out on JSIN.
Right. And maybe I jump ahead. Well, you can't find that out, but also you can't do district searches on JSIN, right? It's just nationwide.
Yeah. JSIN is just nationwide. You can't do district and you can't do circuit. Yeah.
As you point out, 5Ks are treated differently in different circuits.
Yes.
So it would be interesting to say, okay, I know in my circuit they're only ever going to give 2 levels for whatever and do a search within that range. Can't do that here. So I guess that's another reason to call Mark Allenbaugh.
Yes.
But
we do that.
Yeah. So, but go ahead.
Okay. So anyway, so what we're at here, what JSIN found was 1,123 individuals sentenced under 2B 1.1, total offense level 13, criminal history 1, without receiving a 5K. So we have those 1,123 individuals. Now, what JSIN says, for the 701 defendants, 62%, who received a sentence of imprisonment in whole or in part, the average length of imprisonment imposed was 8 months, and the median length of imprisonment was 7 months. Okay. Now, what that means, what this is important and needs to be translated. What JSIN is telling you is that there were 701 defendants that received a non-zero sentence. In other words, they received a custodial sentence. It could have been as little as a day or a month or a few years, but what they didn't get was probation. So this is those 701 did not get probation, and this is the sentence that actually was imposed. Okay. Now, for all 1,123 defendants, so now we're including everybody that also received probation or a non-custodial sentence, the average sentence imposed was 7 months, and the median imposed was 6 months.
Yeah. Okay. So it went down.
Now that does,
by a lot,
well, of course it went down because now you're including the all the probationary sentences.
Yeah.
Yeah.
Okay.
So, but There's a problem with that. Now, the untrained eye would look at these numbers and think, okay, well, they went down and that makes sense. Almost a third of them received no time, and it only went down a month. The average only decreased by a month, and the median only decreased by a month. That should raise an eyebrow right there. It should have went down a lot more if you're talking actual custodial sentences, non-custodial sentences,
Okay.
where over a third of them received 0.
Yeah. So how do we account for that?
There's a problem. There is a problem in the coding for JSIN that the commission really needs to address immediately. Now,
so
what I did,
this is a bug. It's just
a bug.
It's just a bug. Okay.
Well, a big bug.
A big bug. Yeah, yeah.
A big bug, and I don't know how prominent it is. Given, I haven't done all the millions of permutations that one can do for guideline and offense level criminal history category. But for this particular permutation, there's a problem. Now, we're going to go back to my.
And by the way, it's a bug that's deeply unhelpful to us because on your data brain, you're saying if a third of these people are non-custodial sentences, those numbers should be lower than they are.
Yes.
Yeah. And if they were lower, they'd be helpful to us, to the defense.
Right. Okay. So now what I did, can you see the power or the Excel spreadsheet?
Yep.
Okay. So there's a couple problems. I'm going to go with the big one first. If you look down here, what I did is I found the 1,123 cases that JSIN found. I got the exact identical cases over the last 5 fiscal years using the same search parameters. And I found 1,123. Ignore the red one for a second. That's a problem case, and I'll get to that in a second, but it's a minor issue. Excel doesn't make any mistakes. Look at the average. Here is the average for all the sentences imposed. It's only 5 months.
Yeah.
Not 7 months. Look at the median. The median is 1 month, not 6.
Not 6. Yeah, that's
a hell of a difference.
Yeah, yeah. That's a little bit of a difference.
There's a bug.
Yeah.
They're calculating something incorrectly. And there's another bug too, just with this, and this is just one permutation of possibly millions. Remember, we selected for the 1028A consecutive
Identity
sentences,
theft.
we selected 0 to exclude those. Well, the problem here is you could see, I think I gotta move this. Over here on the right-hand side, it said, can you see where it says stat min?
Yes.
Okay, these are the statutory minimum sentences for each of these 1,123 defendants. They should all be 0.
Yeah.
Well, here's one. This last one is 36. How did that sneak in there if it was supposed to be taken out? Well, what I suspect is what the commission staff or whoever they hire to program this is only going in and taking out those that received exactly 24 months as a stat min, which would be the 1028A cases. So if there was a 1028A and he received 24 months, you're out. But if you got a 1028A, which this individual did get a 1028A, but also another consecutive sentence of 12 months. So those were added together to get 36. The programming misses that.
Gotcha.
And so that now in this particular case, it doesn't make a bit of difference in terms of the data output, but it can. It can if you're talking about a smaller data pool, or there might be more of these. Let's say if we went up to, I don't know, offense level 18, there could be dozens of these 36s or 48s or 12s or 6s. There are other mandatory minimums other than 1028A. And really what you're trying to eliminate here are all mandatory minimums, because now you're talking apples to apples rather than apples to oranges. As soon as you get a mandatory minimum in there, it's going to change the data and jack it up. And that's not good for defendants. So here, this is a big problem here. Here is another issue that I do not like about, that's very misleading about JSIN. And I'm going to get right back on there. Now, if we scroll down a little bit, can you see JSIN again?
Yep.
Okay. So we're scrolling down here, and this is helpful. We have this little bar chart here. It's a horizontal bar chart, and what it shows is sentences imposed relative to the guideline range for defendants in the selected cell. And this is helpful because what it shows, especially if you're a judge, well, how many of these individuals received within guideline sentence? Only 31%. Wow. So judges generally are not following this guideline at all. Is it because of 5Ks? No, only 12% got a 5K. And then the majority received a downward departure or variance. We see here 56% received a downward departure or variance. Wait a minute. Wait a minute. There's a 5K in here? I thought we eliminated 5Ks. Why are we even talking about number of 5Ks?
Yeah.
That's confusing.
Yeah.
That should cause you, now you have to go down to the note. You have to go down to the note here to read that the figure includes basically everybody that received a 5K. Okay, well, why not have this breakout here based upon the data that's actually reported, or the sentencing, the statistical analysis that's actually done? That would be very helpful, because I mean, this is helpful too, but you have to really understand that you're looking at a different data set here. And this it's not made clear enough with this little note down here. It's because, and the reason why that's important, and I'll show you here in a second. Let me get to this. And this would be important for me as a judge. Well, actually, before I move on to that, this is also misleading when the commission writes that these 56% are downward departures or variances, because one might think immediately that, as I did, that these are court-initiated downward departures or variances, that they have nothing to do with the government. That's wrong. They also include government motions for a downward departure that are non-5K related, non-5K 1.1. There's also 5K 3.1, which you're probably quite familiar with out in the District of Arizona for fast track. So it also includes those which you might not want to include. It would be, I don't know why I would want to include those that
well, that's probably helpful in the grand scheme of for us, because those are major departures, and that's 70+% of the caseload in Arizona are going to be these way below guideline sentences.
Yes, but it could skews the data, and that, believe it or not, from a numbers perspective, it may not be helpful. It may not be, and there's also other government departures too. And more to the point, if you're up in front of the court and the court asks you, does this eliminate all government motions? You would be wrong to say, although you would be reasonable to say, based upon just looking at this, you would be wrong to say that, yes, it excludes all government motions. That, in other words, 56% of the time, courts varied on their own below the guidelines. That's not true. That's not true. And nonetheless, what is helpful here, and I'll tell you, Doug, one of the things that's so beautiful about doing the sentencing statistics and sentencing analysis is, contrary to Mark Twain, you don't have to spin the numbers. The numbers speak for themselves. The numbers are the numbers, and that's it. So, while you're right, sometimes maybe having a bunch of 5K 3.1s thrown in there and nobody knows about it could help the data. It's not necessary to do that, because even without those, the data is very helpful. And just being really authentic and true. So, because what you want to do for courts is not to try to spin something, but give them, here's the truth, judge. This is exactly what's going on. And you could go to the commission and they're going to give you the exact same data. And if you don't trust me, have the commission do it, have the government do it, have somebody else do it. But the numbers are what the numbers are. And that's what's so beautiful about this. And that's why I'm glad that the commission is doing this. They're just going about it in kind of a clumsy way right now.
Well, do you think that, I know you said you've already pointed out to them some of the kinks, the bugs. Do you think they're listening? Do you think they're going to fix this stuff? I mean, is that the whole point of this
I don't know.
trial?
I have not received feedback to that particular email yet, or haven't received a response, which is kind of odd because I email commission staff, not infrequently, and I usually get responses pretty timely. But this particular issue, I haven't received a response yet. So that tells me that they're investigating it at the very least.
And I just wonder, from a practice perspective, if you start seeing this stuff in the report, if you don't like, I mean, if you like the data, maybe you don't object to it, but this is probably something you should be filing routine, if not a formal objection, to just put it in your sentencing memo to say, I understand what's in this report, but you need to understand this is a trial period.
Right.
This data has flaws. The programming has bugs, and to the extent you're going to rely upon this to impose a sentence, that's problematic for the following reasons. And you may be able to include generic reasons that we've talked about, the bugs and etc., or you may need to do some specifics.
Right.
It's just in order for them to get the true picture of the data that the data is telling. If you subscribe to the theory that the data doesn't lie, it is, the numbers are what they are, which I know you do. I keep thinking about one of my favorite quotes from my hero Homer Simpson, when he was on the news program with Kent Brockman, and he said, people can come up with statistics to prove anything, Kent. 14% of people know that.
Right. Well, see, here, by the way, here's another beauty about sentencing statistics generally, and I'm not putting a plug in for myself, is that when JSIN or Mark Allenbaugh is reporting on the data, it's not some sample, and that's where data can be skewed and manipulated depending on your sample size. And we know this from politics and polling and all this stuff. There's a whole science around sampling data and then try to make an inference out of that sample to the whole class. That's not what we're doing here. We are looking at the entire universe. There's no sampling involved. This is it. This is everybody that meets these criteria. And so that is an additional level of obfuscation, if you will, that's eliminated by looking at the entire universe of the data. So at any rate, I'll get off my high horse here for a second. But one thing I just wanted to share with the audience is once you take out all those 5K 3.1s and whatnot, yes, you get a smaller number in this particular case for the downward variances, but it's still high. 47% of all the sentences were the result of a true court-initiated downward variance or departure that did not come from a government motion, certainly whether it was a 5K 1.1 or 5K 3.1 or a Rule 35 or something along those lines.
It was 56 with all that other stuff built in, right?
It was 56 with all that other stuff built in.
Yeah.
So, and that other stuff is noise still. So what this shows is a plurality.
Good too. Yeah.
Yes, it is good too. It's a plurality.
Because some judges may be smart and discount the JSIN numbers to say, oh, well, that includes 5Ks and bloop, bloop, bloop. So I shouldn't look at that. Well, okay, maybe you shouldn't look at that, but still look at this. 47% is still a pretty damn high number.
Right. Yes. Exactly. It's a very high number. Now, to show one more thing here. So, and here, speaking of numbers, one thing that I don't like about JSIN and I don't like about many statistical reports is they give naked numbers. We know, according to JSIN, incorrectly, the average sentence for this group of offenders was 7 months and the median was 6. And we know that's incorrect. It was actually 5 months and 1 month. Okay. Or really 4.9. The JSIN rounds up to the closest whole number, by the way. So here I took the same data and I made what's called a box plot. And this is actually much, 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 much more informative to a court rather than just some naked number. So as we know, out of those 1,122, so we're going to take out that one guy that was in there that shouldn't have been in there that had a 36-month mandatory minimum. What we know now, what this basically shows is that 75% of all defendants received a sentence of a year or less. And that's really significant. Yes, we know that that 5 months was, or 4.9 months was the average, but just about everybody, 75% received a year or less. And remember, the guidelines start at a year. The bottom of the guidelines is a year. So 75% of all the defendants in this class received a below guideline sentence. And even more so, the median here, and for those of you who forgot statistics, high school statistics, the median is basically the literal halfway point. So we take all the data, all 1,122 sentences, and we line them up from 0 all the way up in numerical order to the very top, in this case 30 months. And we picked the one exactly in the middle, and the one that's exactly in the middle was 1 month, meaning half of all these defendants received a month or less. Half received a month or less. When you visualize it like this, it's much more impactful for a court than just some naked number of 5 months or 1 month. Because what gets lost in this too is how many people received a sentence of no time? That we can't really we can infer a little bit. And JSIN, this is what's important with JSIN. You can infer who received a non-custodial sentence. Let me just go back to JSIN real quick to show everybody. So what JSIN says here, and I think JSIN's correct, out of the 1,123 defendants, 701 received a sentence of imprisonment in whole or in part. That's 62%. What does that mean? 38%, or over a third, received a non-custodial sentence. That's very big. That's something very important to show to a judge, because that's certainly not going to create unwarranted sentencing disparity if over a third of your class of individuals, class of defendants, received a non-custodial sentence. That's significant for a judge to understand.
Nice. All right. Wow.
So at any rate, that's just really, one example of certainly of how JSIN works, but also I think how the problems with JSIN, that it should not be accepted blindly.
Right.
That certainly, counsel really should go out and do JSIN him or herself to make sure to double check that the probation officers did it correctly and make sure that they check the box, but also understand that the data could be wrong. Now, I know most people don't have access to the commission's actual database to double check the data like I have. So contact me or contact the commission and say, hey, we're doing this. I got this big sentencing coming up. They ran this data on JSIN. I need that data. I need to verify this is correct. Because as I just showed you, this is a lot of defendants, 1,122 under TOL 13 and 2B under 2B 1.1, final offense level 13, criminal history 1.
Yeah.
JSIN is completely misreporting what the average and median sentences are for all those individuals. It's not 7 and 6 months. It's 5 and 1 month. That's huge.
Right.
But you wouldn't know that unless you actually check the literal data. And
I want people to understand now. So question everything just because it's in there. Don't accept it. That's sort of a baseline. But I have had some feedback, and I know you're not going to love to hear this, and it's very few and far between, but some lawyers who listen to the podcast and all of our sentencing stat stuff says, my judge I don't really think this makes a whole lot of difference with my judge. And I say, well, I think it does. But the fact that they're now putting it in pre-sentence reports because this is a resource created for judges to help them understand tells us unequivocally that, maybe not every single judge in the planet's going to care about this, but by and large, this does make a difference. Yes. And you do need to be talking about sentencing stats in every case, regardless if it's in your PSR under the JSIN trial run or not.
Yes.
And I also think that if it is in your PSR now, that's probably, especially for CJA lawyers who think I don't have resources to hire someone like Mark to do this. Well, now if it's in your pre-sentence report and you have to confront this data, you
Yeah.
should be going to the court and saying, this is an issue now. They've made it an issue. I need to get my own analysis.
Yes.
And so start
That's absolutely
asking for the money to dig into these stats and make sure that they're right, because you don't want the wrong stats going to the judge if that's what they're basing their sentencing decisions on. And we're going to see more and more of this, I'm guessing, not less and less of it. That's why this whole trial period thing is happening. So,
And
that,
Doug, I just like to
yeah,
add one last thing.
yeah,
JSIN, once it's perfected, once all the bugs are out, isn't just a great tool, I think, for judges and counsel and the parties at sentencing. It's also a great tool for appeal. We haven't seen a lot of successful appeals based upon the substantive reasonableness of a sentence. And frankly, I think that's because of a dearth of statistics being presented to appellate courts. And certainly the appellate courts aren't going out and trying to validate a particular sentence. Now with this tool, certainly CJA counsel, public defenders, and private counsel too can use this to evaluate the sentence that was imposed and to see if it was just completely outlandish. Maybe they got a 30-month sentence in this particular case, as opposed to the more typical sentence of 5 months or a month or less. And that could be an argument to show that the sentence was substantially unreasonable. And that actually the last thing too is, now, as we know, with compassionate release, here this tool can also be used with respect to compassionate release cases. The commission now has said that one of the grounds for compassionate release are unusually long sentences. Unfortunately, they didn't identify or define what is an unusually long sentence, but just going with the dictionary definition, it's something that's out of the ordinary. And how else can you express or demonstrate that a sentence is out of the ordinary other than through statistics? And this is a great tool that counsel and pro se potentially should be citing when they're seeking compassionate release.
When I'll add another way that this could be useful: when we as an attorney are deciding whether or not to take a plea, or that we can give the client at least a little bit of a better understanding or picture of how the sentence could shake out, at least what the odds are. I know we hate to give odds, but you can see the ranges in the statistic. But I have a question about that.
Yes.
How do you factor in trial versus non-trial, aside from just raising the offense level by 2 or 3 levels because you're presumably not getting acceptance of responsibility?
Well, so that's a very good question. The quick answer is that it doesn't make a difference, because that's already factored in as in this case, the total offense level of 13. So this is going to include everybody that went to trial and got a total offense level 13, and everybody that pled guilty and got a 16 and it was reduced back down by 3 levels because of acceptance of responsibility. So it's going to include both those individuals. At the end of the day, the guidelines don't really care how you got there, at least in theory. And in theory, it shouldn't make a difference between the trials and the sentences, or trials and pleas. But in practice, it actually does.
Yeah.
But you need to dig. You need to dig into the actual data to do that. You can't do that with JSIN. But guess what?
Yeah.
Well, I can.
It's probably it's probably a whole other podcast in terms of the trial penalty.
Yeah.
Because that's never going to be reflected probably in this what we're doing. But that's another podcast. Here's what my greatest compliment can be to you. I get a little bit my eyes glaze over with the data. It's not how my brain works. I can always drag it down to the lowest level with movie references and Simpsons quotes, but you managed to make these stats sexy. And I would just like to reflect back on some of the language you've used here. Naked data. You talked about kinks, then all kinds of kinks. And so I just feel like, something special going on that you've made sentencing stats sexy. So anyway,
Thank you.
when the world, I would put the actual song from Get 'Em to the Greek in the podcast, but then I'll be kicked off YouTube for copyright infringement. But it would go something like this: when the world gives you a JSIN, call Mark Allenbaugh. Call Mark Allenbaugh. How's that?
Very good. Very good. Thank you.
Okay. Well, yeah. Check out the show notes for all that stuff if you need to. And Jason's where it's at. I'm thinking about Friday the 13th now.
Yeah.
I need to stop. Okay. That maybe I'll play that on the soundtrack. Anyway, I'm gonna cut all that garbage out. Probably I'll have to. But thank you, Mark Allenbaugh, as always, for your wisdom and wit and all of it. And I'll see you soon on Set for Sentencing, to be sure.
Thanks, brother. Appreciate it.
That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.